I said, John, thank you, provided. Be seated, thank you.
All right, I want to take up the case involving Mr. Kelly and all parties affiliated with that particular case as it relates to those that have been charged. If you will, bring out Clayton Thomas Kelly, please.
Okay.
Judge, look at the front.
You may. Kelly, you previously have been before the court as it related to an original charge dealing with this particular matter. You've also got two additional charges since that occurred. You're charged with filming without permission of an individual in violation of Section 972963 of the Mississippi Code of 1972 as amended. Carries a potential penalty up to 5 years and/or a $5,000 fine. You're also charged with conspiracy in violation of Section 97(1)(1) of the Mississippi Code of 1972, which likewise carries a 5 years and/or $5,000 fine. You understand that?
Yes, sir.
As previously, you understand that anything that you say may and can be used against you.
Yes, sir.
Further, that you're entitled to an attorney. If you can't afford one, one would be appointed for you. But you have Mr. Camp, who's been representing you in this matter, and he still represents you. Is that correct?
Yes, sir.
While you're incarcerated, you will be able to consult with Mr. Camp, and he'll be able to consult with you anytime that he or you so choose. In addition to that, any family members that you might have or any friends that you have can visit you while you're incarcerated. However, it's subject to the terms and conditions of the Madison County Detention Facility. You understand that?
Yes, sir.
You also have right to what's called a preliminary hearing. And the purpose of the preliminary hearing is to determine whether or not there's sufficient probable cause that a crime has been committed. And further, that there's sufficient probable cause that you committed the crime. Do you understand that?
Yes, sir.
All right, as in the previous charge, you're entitled to bond on each one of these counts. Does the city have a position relating to bond?
Your Honor, I believe that on the two new counts, bond had previously been set on the warrants at $50,000 per count, and the city believes that would be an appropriate bond on each charge, that bond will remain.
All right, bond is set on $50,000 per count. We're also to have a preliminary hearing, as I understand it, and we will proceed with the initial appearances with the other co-defendants before going into the preliminary hearing.
Yes, Your Honor, and we're missing an affidavit. We have not been provided with the third charge. We have the original, I guess, charge that we've already done an initial appearance on, but the only one that we've been provided with right now is this conspiracy. We have not been provided with another affidavit on that charge.
Judge, we can make a copy real quick.
Well, let's do that. Let's do it right now.
Do you want to proceed with the others? Have us sit down.
Mr. Sager. Are you Richard Allen Sager?
Yes, sir.
Do you reside at 164 Merchant Circle in Ellisville, Mississippi?
No, sir, I've moved.
Where do you reside now?
Laurel, Mississippi,
What's the address?
288 Service Road, 39443.
All right, well, Mr. Sager, this is what's called an initial appearance, at which time this court's to advise you of the charges against you and the potential penalty relating to each charge. Do you understand that?
Yes, sir.
You're charged with tampering with evidence in violation of Section 97-9-125-1A of the Mississippi Code of 1972 that carries a potential penalty of 2 years in the state penitentiary and up to $3,000 in fine. You're also charged with conspiracy in violation of Section 97-1-1 of the Mississippi Code of 1972 as amended. Carries a potential penalty of 5 years and or a $5,000 fine. Do you understand the charges?
Yes, sir.
You have a right to remain silent. Anything that you say may and can be used against you. Do you understand that? You have a right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Do you plan on obtaining the services of an attorney?
Yes, sir.
Good. Once you obtain the services of an attorney, he or she shall have a right to consult with you while you're incarcerated at any time he or she chooses to do so. Likewise, any friends or family members that you have would like to visit with you in the Madison County Detention Facility while you're incarcerated may do so. However, it's subject to the terms and conditions and restrictions of the Madison County Detention Facility. Do you understand that?
Yes, sir.
You're also entitled to what's called a preliminary hearing, and the purpose of the preliminary hearing is to determine whether or not there's sufficient probable cause that a crime or crimes has been committed, and further that there's sufficient probable cause that you committed the crime. Do you understand that?
Yes, sir.
All right. You're also entitled to bond. Bond has previously been set at $250,000 per count. City have any position as to the bond, upwards or downwards?
Your Honor, the city feels that the bond previously set is appropriate and will remain as such.
Bond will remain at $250,000 per count. Okay, you can take him back. Take this one too. Martin Mayfield. Mr. Coxell?
Good afternoon.
Mr. Reeves? It's all right. I
Some
don't
folks
have,
just don't wear ties anymore, Judge.
including the judge.
I didn't notice.
Are you Mark Stevens Mayfield? Mr. Mayfield, you reside at 109 Cherry Laurel Lane, Ridgeland, Mississippi.
That's correct.
This says you've already heard me tell the other co-defendants is what's called an initial appearance for you, at which time I'm to advise you of the charge against you and the potential penalty relating to that charge. Do you understand that?
Yes, sir.
You're charged with conspiracy in violation of Section 97-1-1 of the Mississippi Code of 1972 as amended, carries a potential penalty of 5 years and or $5,000 fine. You have a right to an attorney, and I see that you have two very capable attorneys with you, and they will have a right to visit with you and consult with you anytime while you're incarcerated. In addition to that, any family members or friends that you have may likewise visit with you, subject to the terms and conditions and restrictions of the Madison County Detention Facility. You have a right to a preliminary hearing, and as you've heard me state to the other co-defendants, the purpose of that preliminary hearing is to determine whether or not there's sufficient probable cause that a crime has been committed, and further that there's sufficient probable cause that you committed the crime. Likewise, you're entitled to bond on this particular matter, and as I recall, I said bond at $250,000. Is that correct?
That's correct, Judge.
All right. City have any position on that bond?
The city feels that be an appropriate bond and that it should remain.
Judge, I'd like to be heard on that.
I'll hear you.
Yes, sir. Your Honor, this is a, I don't exactly know why there's a $250,000 bond on Mr. Mayfield. As I'm telling you this as an officer of the court, in light of the Lee versus Lawson bond factors, he has been a resident in Mississippi since 1962. Well, 57 years. I'm sorry, I might have been me. It was 62. And his wife is sitting back here in the courtroom. She's with a white sweater on. They live in Bridgewater, Mississippi. Before that, they lived in Ingleside, and before that, they lived in Jackson. He's a licensed attorney in the state of Mississippi, does land work. Is 1 year younger than me in terms of years of practice, so he's going on 33 years of practice. He has absolutely no criminal record whatsoever. He's not a flight risk. He's not a threat to anybody in the community. He's got 2 sons, one who lives out of state and one who just graduated from UNC, a biomedical degree. And there is just absolutely, under the Leavitt versus Lawson factors, there's no reason to have a $250,000 bond on a respected member of the community. The purpose of bond is to make sure he shows up in court. He's got big clients that he represents. There are major clients that I don't want to bring into this that he does work for, and they're major components in this community. The whole community of Mississippi. And he's got active cases going for those individuals or those companies. And I don't know the purpose of a $250,000 bond. I mean, quite frankly, it stuns me and shocks my conscience. And he ought to be released on his own recognizance. And if that's not possible, being a member of the bar, does the city attorney expect him to flee and give up 33 years of law practice? He should be released on his own recognizance, Your Honor. If not, it should be something like $25,000 bond at the max. There's no cause whatsoever for a bond in this situation.
You through?
Yes.
Does the city have anything to respond to that was brought out in the argument of counsel for the defense?
Judge, based on the nature of the charge and the facts surrounding the charge, the protection of the community, the city feels that the bond is overstated, based on the charge and all those factors.
I think for the time being, the bond will remain at $250. It may be reconsidered a little later, but at this point, it will remain at $250.
Is that going to be in a written order that I can take, Your Honor?
Sure.
Would the city attorney give me a copy of the affidavit so I can take that with me when I leave?
Absolutely. I want the defendants to be given everything they're entitled to get. Do you all need to consult with your client further?
Yeah.
Y'all can go back there with you. Thank you. Give that to Trey, please. All right, does that conclude the initial appearances for the co-defendants in this particular case at this time?
I believe so, Judge.
All right, you ready to proceed with the preliminary hearing on Mr. Kelly?
City, Mayor.
Defense?
We're ready, Your Honor.
All right, call your first witness.
City will first call investigator Vicky Curry.
Do you swear affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, proceed.
State your name and city, please.
Vicky Curry,
How are you employed?
as an investigator with the Madison Police Department,
How long have you been employed in that regard?
approximately 9 years.
Are you familiar with a charge currently pending against a Clayton Thomas Kelly for exploitation of a vulnerable adult in this court?
I am.
And have you been involved in the investigation that brought about that charge against Mr. Kelly?
I have been.
Are you familiar with the information and the evidence related to that charge?
I am.
If you would, investigator, could you share with the court what the general basis is underlying the charge against Mr. Kelly of exploitation of vulnerable adult?
I believe it was on May the 15th, this department was notified of a possible exploitation of a vulnerable person at St. Catherine's Village. After further investigation, we discovered that Mr. Kelly had posted a video for a period of time on his YouTube page or YouTube blog. We reviewed video that the complainant had acquired. After reviewing the video, it was determined that we should continue investigating, which we did. We contacted Mr. Kelly at his residence.
All right, if you would, tell us from reviewing the video that you just mentioned, what did the video depict?
It depicted several pictures of a couple, Dad Cochran and his assistant, I believe is who it was. There was a narrative in the video. At the end of the video, it referred to the victim and showed a picture of her in her residence at St. Catherine's Village in her bed, in a state of unconsciousness is what it appeared.
Okay. All right. Are you able to tell, and you viewed this video?
I did.
All right. Are you able to tell from what vantage point or about what range or distance the images of the victim would have been taken in that video?
It appeared to be fairly close, right next to her bedside.
Did that appear to you to be inside the room
It
of the
did.
victim?
It did.
All right. Now, after viewing that video and what it depicted, what, if any, action did you take after that?
Myself and Investigator Harrison made contact with Mr. Kelly at his residence. He agreed to speak with us. He confirmed that he had posted the video and that he had also, after posting it, determined that it probably wasn't appropriate and he took it down.
Now, I believe you mentioned St. Catherine's Village. What type of facility is that, if you're aware?
It's a retirement village, and they have facilities on the property that range from garden homes to Alzheimer lockdown units.
Okay. What type of unit, what unit, if you're aware, with the victim in this?
She was in an Alzheimer's unit.
And generally, what is the condition of the victim?
Non-mobile, non-verbal.
To your knowledge, is she aware of her surroundings?
No, sir.
Is she able to communicate in any manner whatsoever?
Not to my knowledge, no, sir.
And approximately, what is the age of the victim?
Late 70s, I believe. Maybe 80.
Now, did Mr. Kelly, in the course of your talking with him, explain why he had gone there to take that video?
He did. He said that he was wanting to appropriate a video or likeness of the victim so that it could launch his blog and radio show.
Now, based upon your knowledge of the victim's condition, as you just stated, based on that condition of what you're aware of her abilities or her inabilities at this point, based upon her medical condition, is she able to communicate what she wants or what she allows?
No, sir.
Now, the unit where the victim lives in the St. Catherine Village complex, is that here in the city of Madison?
It is.
So is it your understanding from speaking with Mr. Kelly in your investigation that once Mr. Kelly was able to enter the facility, enter the victim's room, that he then used this video to post on the internet in a video that he created?
Yes, sir.
And he told you that he wanted to do that to help further or gain attention for his blog or himself as a reporter of some sort?
Yes, sir, journalist.
Of course, we don't just want to. Now, the city attorney would.
Cross?
Thank you, Your Honor. Let's go over the timeline, first of all, to make sure I understand exactly how this happened. You were first contacted on May 15th, is that correct?
Yes, sir, I was.
And who contacted
My police chief and my assistant chief.
you? Okay. And so obviously somebody had contacted them, is that correct?
Yes, sir.
Okay, who had contacted them?
I don't remember the man's name. It was an attorney at Butler Snow.
So an attorney from Butler Snow contacts your police chief about a possible criminal act, is that correct?
Yes, sir.
Okay. And then the act actually occurred, if I'm understanding, back in, is it April 20th?
I believe that's when the video was posted.
Okay.
April 26th, I believe, is when the video was posted.
Okay. So it's posted on the 26th. When did he actually go there?
According to Mr. Kelly, he went there on the 20th.
Okay. So when the photo was taken, it's the 20th is basically what happened.
It was Easter Sunday.
Okay. So a month goes by, or almost a month goes by, before it's given to you to actually start doing an investigation. Would that be correct?
That's when it was reported to the police department, yes, sir.
Okay. And during your investigation, did you see that anything further had happened between this 4/20 and this May 15th date? Did anything, any other photos? Did Mr. Kelly attempt to go to St. Catherine's or anything?
Not to my knowledge, but on the 20th, that was his third attempt to try and obtain the photo.
Okay. And then after the 20th, no further attempts whatsoever?
Not at St. Catherine's Village, no, sir.
Okay, and that's the only place that he would go in to get a photo of her, because that's where she's at, right?
I would assume, yes, sir.
Okay. And when did you actually arrest him? It was after the 15th, is that correct?
Yes, sir.
Okay. And so it would have been just about a month from the time that the incident actually happened to the time of the arrest?
And I believe the 15th was on a Thursday. I received information late Thursday afternoon. We spoke with Mr. Kelly Friday afternoon, and then after speaking to him, determined that an arrest would probably be warranted.
And I think you made a point. You said that he was acting as a journalist. That's what he was attempting to do. Is that correct?
When he spoke with us, he said that the reason he took the blog was because he was trying to further his journalistic career, become an entrepreneur, start a radio show, blogger.
And I guess the issue that he was using this photo for was he believed that the senator was having an affair, and this was furthering, I guess, his presentation of that issue. Would that be correct?
I would assume, yes, sir.
Okay. Now, you're the one who's written all the charges, or who's signed the charges, is bringing the charges forward, correct?
Yes, sir.
Okay. And you agree with me that the photos are not lewd or lascivious, are they?
I believe they're indecent.
Okay. What is indecent? Because our courts have defined what indecent is, and indecent is dealing with the sexual connotation, correct?
Judge, if I may, I think we're getting into elements of crimes he's just been charged with this morning, that he's just had an initial appearance on. My understanding, this is a preliminary hearing on one count of exploitation. He's talking about elements of different crimes.
Well, I was going to request whether or not, or ask whether or not either one of you were going to get into the substantive charges. And I didn't. My understanding is strictly for the charge of exploitation.
That was the city's understanding as well.
And that's why when I was up here, I asked on the prelim, I thought we were doing it all at the same time, all three charges, since Mr. Kelly has already been in jail. And there wouldn't be a reason to, I guess, prolong a prelim on the other two charges, which come out of the exact same.
That depends on what comes out of this particular charge. It may become moot, for all we know.
Do you want me to just keep it with the initial charge?
Yes. I don't think you yourself have had enough time in which to explore the potential ramifications as to the other two charges that he was just charged with. So, in fairness to your client, that's what needs to be taken into consideration.
If I will, let me get a different folder than your own.
All right.
So the original charge that you filed, may I approach the witness, Your Honor?
You may.
This is the affidavit for the original charge, correct?
Yes.
Okay. And the original charge is just willfully, intentionally, unlawfully, and feloniously, you have illegally and improperly used Rose Cochran, a vulnerable adult, in her image for her own purpose, for his own purpose and benefit, without her consent.
Yes.
Okay. Now, in the statute that you charged them under, which is the exploitation of a vulnerable person, there's only three ways that you can go about doing that, correct? One of them is taking a person's money, correct?
Yes.
Sexual assault would be the next one. And then the third one's going to be neglect, correct?
This exploitation, 434719, has abuse, neglect, and exploitation. Mr. Kelly illegally and improperly used Rose Cochran and her image. He appropriated that image and used that for his own benefit.
Now, how much money did he get? What does your investigation show? What currency has he gotten out of this?
I haven't seen that he's gotten any currency.
Because in looking at the statute, it says a person who willfully exploits a vulnerable person where the value of the exploitation is less than $250 shall be guilty of a misdemeanor. Now, in your investigation, that's still ongoing as of today, you haven't seen anything where he has gotten a dime, correct?
Not at this point, no, sir.
So you can't even tell the court whether this is a misdemeanor charge that you're bringing or even a felony charge, correct?
I believe that her image is priceless and he shared it with the public, which without her consent or her family's consent.
Priceless. Now, he's cooperated with you at all times, correct?
For the most part.
Yes, I mean, there's not a question that he is not, when you've asked him, he's provided you with the information. When he's met with you, and also all of this is met together, correct?
Correct.
Okay. And I think you're aware, I think he lives in Pearl, is that correct?
Yes, sir.
What is his profession? What does he do?
He works for EMC Squared, I believe is the name of the company.
And I guess it's a data storage company is what it is?
Something along those lines, I believe.
Okay. And you're also aware that he has a wife and child?
I am.
Okay. And you're also aware that he has substantial connections to the community, correct?
I'm not aware of any connections to the community.
And tell us about, does he have, I guess you did a search to see if he has a criminal background? Is
He
that
does.
correct? Okay. And what is his criminal background?
He's been arrested a couple times for narcotics charges. I believe once for cocaine, once for marijuana with intent to distribute.
And he's always appeared every time in court. There's nothing to show that he is a flight risk, correct?
I haven't seen anything that said he was.
And you're doing the investigation. You're the one that would actually know his background, because that's what you're looking at, correct?
Yes, sir.
And there's nothing in his background that would lead you to believe that he's a flight risk, correct?
I don't know that. I have not seen anything that says he's been a flight risk in the past.
Now, you're aware that I think you even talked to the wife, is that correct?
Yes, sir.
Okay. And you know he has a good job. When did, I guess at some point you decided to file other charges, when did that occur?
I believe we filed the photographing charge on
Page 22.
the 20th maybe, or the 21st, and the other charge we filed this morning.
And you just decided that I guess there was another statute that you thought was violated at the same time, is that basically what it was?
Yes, sir.
Okay. And my understanding is you're saying that he was using her to his own advantage is basically the part of the statute that you're referring to?
Yes, sir.
Okay. Now, beg the court's indulgence, Mr. Mullins.
Absolutely.
No further questions, Your Honor.
Read your right.
Investigator, you were asked about monetary value
Yes, sir.
in relation to this exploitation statute. Are you familiar and aware that the statute states that the value of $250 or more in exploitation of vulnerable adults and crimes of felony?
Yes, sir.
And if I'm understanding your description of the victim correctly, she has advanced dementia
Yes, sir.
to the point where she cannot communicate. To your understanding, based on your investigation, is she at all aware of her surroundings?
No, sir.
So she can't communicate, she's not aware of her surroundings. Does she require complete and total care of others?
Yes, sir.
And the video that you saw where Mr. Kelly goes in and takes the video of her in her room at St. Catherine's, I believe you said she appeared to be asleep,
Yes, sir.
that she appeared to be in sleeping clothes.
Yes, sir.
So, Mr. Kelly goes in, he takes the video, pictures of this lady who can't communicate, who's not aware of her surroundings, who's totally dependent on other people for her care. When she's in her sleeping clothes, in her bed, apparently asleep, walks into her room, which is her residence,
Yes, sir.
her home, and takes a picture of her without her consent. Is that right?
Yes, sir.
So, do you think under those circumstances, investigator, based on your investigation, the facts you're aware of in this case, that vulnerable lady's image taken under those circumstances, that her dignity and the use of her image like that her dignity and use of her is worth more than $250?
Absolutely.
All right, step down. Call your next witness.
John, if you all see with that.
Tender to the defense.
Your Honor, without going to produce any witnesses, we'd just like to be heard on the issues.
All right. I'll hear you.
Your Honor, first of all, I think the detective is saying that the image is priceless. Obviously, it's not going to meet the muster of the charge. It's going to have to be an evaluation that this court is going to have to look at whether or not it's a felony or misdemeanor. And the detective simply saying that that's valued at more than that, I think doesn't meet the standard on this, especially on this charge. Something also that they have to show is that it was what the intent was done for in this situation. And that's part of the actual charge itself that has to be done illegally, and it has to be done for a purpose that would be other than furthering the journalistic, I guess, endeavor, which is what the testimony is at this point. Because of that, I don't think that they have met the burden to even have this case presented to a grand jury. We would ask that the charge, I guess, be quashed at this point, and on this charge, you be allowed to leave. If the court disagrees with that, I'd also like to be heard on bond after the prosecutor addresses.
All right. Response?
Your Honor, what this boils down to is, yes, most of the cases we hear about exploitation of a vulnerable adult have to do with some physical act against the victim, or they have to do with stealing something of easily identifiable monetary value along with the victim's property, stock, bonds, cash. This is not one of those cases, and that's pretty clear. This is a very simple case. We've heard what Mr. Kelly did. The fact is that in an exploitation case, it doesn't have to always be money. It doesn't always have to be a physical violation of some sort of assault. What you have in the plain reading of the definition of of Exploitation and Vulnerable Adult Act, as it pertains to this case, is the improper use of a vulnerable person. Because the statute reads, improper use of a vulnerable person or his resources for another's profit, advantage, etc. In this case, resources weren't used. The person was used. As Investigator Curry said, by appropriating her image, which is something that Mr. Kelly could not get, absent walking into her home, her nursing home room, photographing her when she's completely unaware of what's going on. Certainly without her consent under those circumstances. So he's appropriated her image without her consent, which is something that belongs to her when she's laying in a bed in her home in a nursing home. It didn't belong to Mr. Kelly. It wasn't his to take. So why did he do it? Counsel talked about intent. His intent, as Investigator Curry testified, was to further himself and his actions in being some pseudo-journalist, blogger, poster on the internet, whatever you want to call it. But under the statute, that is for his profit, advantage, or unjust enrichment. That was for Mr. Kelly's advantage that he did that. Took that photograph and used it that way. That's what he told Investigator Curry, as she's just shared with the court. Now, Investigator Curry also stated that under those circumstances where we find this victim and what she suffers from and the way that she lives and where she lives, that to go in there and violate the sanctity of what is her home, to violate her privacy, to violate someone who's in the condition she's in, and to do those things without her or anyone on her behalf's consent, and to violate her dignity, quite frankly, that's worth a heck of a lot more than $250. So the city would offer that it has, as the court well knows in the test of all inferences being taken in the light most favorable to the city, more than established burden of probable cause at this stage for this charge to continue on and be bound over to the jury, and that's what the city would request at this time.
Any rebuttal?
Your Honor, I would still say that the statute's very clear, and it says that there has to be a determination of what the value is. Right now, what you're seeing is you have a case that has never, ever come before in Mississippi. There's only 3 categories where these cases come into play. 1, sexual assault. That didn't happen. 2, taking somebody's money. And then 3, neglect. That's all the cases that have been dealt with in the state of Mississippi deal in those 3 categories. This one's very unique in the situation that you have. And partly, that's why you have this threshold. And you're gonna have, there has to be some tangible evidence of whether or not what the value of that, not just saying that a person's image is priceless. If they can't give you some tangible evidence, then it is a misdemeanor and should be dealt with in your court. Otherwise, it should be a felony and then bound over. That has not been brought up at this time. Something else that I think is very interesting that has come about is you see the intent for the actual photograph was a journalist trying to further a story. Okay? That shows you what the intent was, not a lewd, lascivious intent or something of that nature. It was a journalist that's after a story, which brings up part of the statute also, which is they have to show that it was illegal for them to be there. And what the actual, it says it's illegal or improper And if he's using it as a journalist, then that definitely may not be a illegal or improper use of the image.
Even though there's an invasion during the process?
And Your Honor, I think there's, the issue is, and it hasn't been shown at this point, was he in a place that he was not supposed to be? Did he take a photograph of somebody that he could not take a photograph of? Because as you're well aware, you can make a recording in this state, and it could be an audio-visual recording, it could be a voice recording. And as long as one of the parties knows that it's happening, then that's legal. Those are some issues that they have to show that it's an illegal, that he did something illegal. They have not shown that it's illegal. They have shown that there's no consent. They haven't shown that that's not, I guess, an element. I think that they have not met their burden, and we would ask that the charge either be a misdemeanor here, or at the most, or we would ask that it be quashed in its entirety.
Well, if this were a case on the merits where all the evidence that's been made available is fully flushed out for a jury to make a determination, or a judge if reach a jury, the purpose of this hearing is to determine whether or not there's sufficient probable cause that a crime has been committed. And this court is of the opinion that there was, in fact, sufficient probable cause that a crime has been committed. It's also sufficient probable cause that the defendant, by his own admission, in fact, committed, probable cause-wise, not beyond a reasonable doubt, conducted himself in a manner that results in probable cause as it relates to whether or not he issued, or whether or not he committed this crime. So the motion is denied. The defendant is bound over to the grand jury. Now, we'll hear you on your bond.
Yes, Your Honor, if I may approach, I have a document for the court.
Prosecutor, seen it?
I believe you get a copy of it. I don't know what it is. It's just a
Okay, and the purpose being?
Your Honor, the purpose of the document is to show that he satisfied his obligations to the circuit court. He met all the requirements. He was released off his probation after fulfilling everything, which goes to the issue of is he going to show up at court, which is one of the major prongs in determining the amount of bond in this situation. Right now, I believe the bond on this charge is $100,000. We think that's extraordinarily high in this situation for a number of reasons. The testimony at this point is you have an individual with a good job, you have an individual with substantial ties to the community, you have an individual that has shown a propensity to fulfill his obligations to the court and show up at the circuit court and finish his probation. We believe that the $100,000 bond is excessive. We would ask for a bond in the amount of more of a $10,000 range on a felony. Something in that nature would be more appropriate, especially given that there was almost a month from the time that the incident actually occurred until it was reported and then the arrest occurred. No further actions took place during that time, according to the investigation that the police department made, which shows that he is not a risk to the general population. We would ask that a bond in the amount of $10,000 would be appropriate.
Of course, this document you presented me related to his prior conviction on possession of marijuana. Is that correct?
I'm sorry, Your Honor?
The document that you presented to me relates to previous charge of possession of marijuana
That's correct.
and a subsequent probationary period of 3 years, for which
Yes.
he complied.
Yes.
I don't see the relevancy of that particular document to sufficiently support your argument that he may not, that he's entitled to a lesser bond because he's not a flight risk.
One of the prongs in determining bail,
I'm familiar with the problem.
yes, is that has he had the opportunity to go back to that he's had a situation where he has had to go to court, and did he fulfill his obligations? And he has fulfilled his obligations. This document is showing that he received a 3-year suspended sentence with probation, that he fulfilled his obligations for probation, and that the probation was terminated at the end of him doing what he was supposed to do, which would be one of the elements for you to take into consideration.
Okay.
Do you need the document for your records, or do you need?
Okay, the motion for bond reduction is hereby denied. The bond will remain at $100,000. The defendant is hereby granted. Is bound over to the grand jury. Anything further on this case?
Nothing from the city.
Defense?
No, Your Honor.
Judge, can we approach the city attorney?
Sure. All right, for purpose of those that could not hear what transpired at the bench, and out of fairness to everybody, the counsel for Mr. Mayfield has indicated that they want to go ahead and put up a cash bond for Mr. Mayfield as set, and waive the preliminary hearing, and thereby this case will be presented to the grand jury via the circuit court. All right, let's take a 10-minute recess.